Good morning. Good morning. Latest immigration news. What's going on? Let's talk about it. Let's address the recent news in the immigration department. Good morning. Good morning. I know it's 11:05, probably sleeping, but I'm just gonna put this live session here, and you can go back to it later. What's going on? Let me share the screen with you. Okay, what else we? Okay, so the first news is we are talking about fee increase. USCIS fees are going to go up. Oh, yeah. So USCIS fees are going to go up. Therefore, you should try to file. If you're eligible to file for a petition, you should try to file, don't delay. Okay. How are they going to increase those fees? We have 70% more for H1B petitions, 129% more for O1 petitions, 201% more for L1 petition. Those are employment based, okay? A 600 surcharge for forms I-129 and I-140. So, like for instance, now the I-140 is 700. If they put a 600 more, it's going to be 1100. Okay. Over 2,000 more for H1B electronic registration system fee, 100% more for adjustment of status, EAD card, and advance parole when filed together. Okay. So this is how it's going to go down. The only thing that's going down here is I-1 replacement, I-90, sorry, application to replace permanent residency card online. So the current fee right now is 455. It's going to be 405, 50% less. Paper, this is online filing, right? Paper filing, 40% less. I-102 application for replacement of the I-94 arrival departure document. It's going up by 40%. This one, I-129 petition for non-immigrant worker, nothing has changed. But this one, it's going up 235 more, okay? And if you go down, I want to focus more on the one that we use, right? See, I-130 petition, I mean, the one that everybody are like familiar with, right? Because those I-29 is basically employment based. A lot of people adjust that is based on family based, okay? But you can go on and look at those prices as well. But let me focus on this one. I-130 petitions for alien relative. When you file online, it's going to be $550, $15 more. Paper filing, $25 more. Okay. Travel document, $15 more. Refugee document, $10 more. Under the age, $10 more. I-140 immigrant petition for alien worker. Okay. Oh, it's going down. I-140 immigrant petition for alien work is going down actually from 700 to 555, which is good. And then what else I wanted to see? Notice of appeal or motion is going to go down, up by $25. I-360 is going up by $15. This is the big one. the green card, I-485, it's going up, okay? It's going to go up by 380 more, okay? So, but for some people it's going down. Let me see which one is going to go down. And you can go on and on. This one, the waiver is going to go up by $80. Unlawful presence waiver is going up by $330 more. Let's see. Yeah, you can go on. Application for citizenship, it's going up by $520 more. It's going to be very expensive. Let's see. Okay. So stop sharing here. Stop sharing. Let me go back. Okay. I'm trying to go back. Okay. So I'm back here. Okay. So as I was saying, right, the fees are going to go up. If you are eligible to adjust status or to file for any type of petition, let's say employment-based, a family-based, humanitarian-based, this is the time. This is the time. Good morning, Heidi. How are you? Bonjour. Bella, bonjour. Good morning. Good morning. Good morning. So this is the time to file. Don't delay because it's going to go up anytime soon. It's going to go up anytime soon. So the point is you have to file. You have to file if you're eligible. You have to file. And we do provide funding, like you can take a loan through us, so you can fund your immigration process. Okay. So what else we have going on? Yeah, I'm going to talk about what's going on in Texas. Let me share my screen again. Let me share my screen again. Okay. So what's going on in Texas? What's going on in Texas is that we know that back in 2023, I believe in December of 2023, in Texas, they signed a state law making it illegal for undocumented immigrants to cross the border. First time offender will go to jail for 6 months. Second time, they can go up to 20 years in jail. And at that point, it's going to be aggravated felony. They'll be deported if they don't collaborate. So the Biden administration, they are planning to fight that. We don't know when they're going to fight it. That's exactly what they said. They're going to fight it. But then lately, the Supreme Court issued a decision prohibiting Texas to put those wires, right, at the border. They have to remove it, okay? But they don't want to comply. So it's pretty much like a fight between the federal government and the state government. So that's what's going on in Texas. If you read it, it's going to say, the title of this article is Texas Attorney General refuses to grant federal agents full access to the border park. Okay. So, and then if you read it, it says here, I was reading here, it says, Abbott and other Texas officials have argued that state actions are designed to discourage migrants from entering the country illegally, faulting the federal government for not doing enough to deter unauthorized crossing. That's why they came up with that law. But the Biden administration keep claiming that immigration enforcement is a federal responsibility, which is correct, right? But they're not complying. So what's going to happen? So this is the law that was signed last month in December of 2023. And this is the Supreme Court that was a law that was signed this year, okay? You see, the Abbott signed a law last month that he hopes will allow Texas officials to arrest migrants on illegal interstate level charges and force them to return to Mexico. The Justice Department is seeking to block that law before it takes effect in March. That law is going to take effect in March, but the Biden administration is trying to appeal that or block it from taking effect, because according to the Biden administration, this is the power of the federal government to control immigration. It's not a state law, okay? It's a federal law. And then early this year, the Supreme Court allowed Border Patrol to cut the razor wire Texas has assembled near the riverbank of the Rio Grande, pausing a lower court order that had barred the agency from doing so. In place, however, since federal officials have not been granted full access to the area. So what I was saying, the Supreme Court has ordered that they have to remove those wires, right? But then the state government, they are not allowing the federal agent to go there and remove it. So it's a fight between federal and states. I don't know who's going to win, but they have to comply with the order of the Supreme Court. So that's exactly what's going on in Texas. Okay, if you are in Texas, my only advice to you is to stay out of trouble, because in Texas and Florida, they have those state laws already in place. In Texas, for example, it's going to take place in March. In Florida, it was already in place. So it's pretty much difficult for undocumented immigrants to maneuver their way over there. So just stay out of trouble, because if you find yourself in removal, it's going to be really hard based on basically their prejudice already, you know? So stop. Let me go back and share another news. I think we have another news. Okay. I don't know what's going on. I'm trying to. Okay. So let me go back. New cost for renewal work permit. Okay, let me check again. Yeah, the work permit is gonna go up too. Let me see. Work permit 765. I don't see 765. Hold on. I don't see I-765. Hold on. $751. Removal of condition for the green card is going up by 165. 765. I don't see it. Looks like the work permit is staying the same way. I don't see it. I don't see anything about it. They're only talking about people who are adjusting status and filing combined, but they didn't separately talk about the work permit for some reasons. So I don't know. I don't see it basically. So yeah, I don't see it. Good morning, Veronica. Good morning. Uladere o Lufe Hinti. I don't see the pricing for the work permit. It looks like it's gonna remain the same. Let's just wait when they're gonna publish those price, this rule. I'll come back again and let you know for sure. But as far as the one that was published there. I didn't see the work permit specifically, you know. Good morning, Veronica. How are you? Yeah, so that's what's going on. Fee increase um, anytime soon, really. It's going to happen sooner than later, probably by next month. But we will know at least the exact date. We will know. Then what's going on in Texas. Then I have another news. Let me see if I can share it. Okay. Okay, let me see what news I have again here. Yeah, so as far as H1B is concerned, certain people can get their stamp inside of the US. That include people who are already in a valid H1B status. Those are the ones who can renew it without going outside. And that program is going to start on January 29, which next week. Okay. What else is here? Okay. And then Syria is going to be redesignated for TPS. What else is going on? What are the I-212 and I-824 waivers? I-824 is not a waiver. I-212 is permission to reapply. So basically, because in your case, for example, you've been ordered removed long time ago, right? And basically, if you leave the country, you're going to be barred from entering the country for 10 years based on unlawful presence for those times. So in order for you not to be barred, that's why they file for I-212 prior to you leaving the country. Okay, it's called permission to reapply for a visa. They're filing it before you leave. So once it's approved, then you can leave the country freely to basically to go get the visa outside. And then the I-824 is for to put your case through consular processing so that NVC can get your case and I don't know if you're going to go to your country or another consulate outside of the US to have your file. That's why they filed the I-24, because originally you wanted to adjust status inside of the US. However, you couldn't for some reasons, your cases, because you have a case pending with BIA, because they have to reopen your case because you've been ordered removed. So you cannot adjust status inside of the US because the motion to reopen hasn't been granted yet. So I guess that's why they want you to go outside. And in order for you to go outside, they have to file those things. I-212 is for you to be able to reapply outside. And then I-824 is for your case to be sent to the consulate. Mark and Tower, this thing, they didn't explain this to you. You're so funny. Like you have somebody else, then you ask questions somewhere else. It's so funny. Sir, morning. They should have explained to you. Sir, good morning. Mark and Tower, they should have explained to you all the purpose of those two forms. By the way, anybody in the system, please like, please share in this live session. Please like, please share. So I'm trying to find another news to talk about. The fee, I already talked about the fee. The fees are going to increase anytime soon. And my friend, if you're eligible, please apply, okay? And if you come through me, we can find a way for you to get a loan. If you don't have the money up front, we can find a way for you to get a loan so you can apply and pay your attorney, okay? So That's really the main thing going on right here. The fees are going to go up. It's going to go up anytime soon. What else? Anybody else has a question? Please put it in the comment. Anybody else has a question? Please put it in the comment. Okay, I'm trying to see what else we have as a news here. Okay. Okay, so there's a class action lawsuit going on. Let me share the screen so you can see it. McIntyre, I already explained to you, there's no such thing as eligibility. They're filing those forms I-212 because you have to go outside to apply, to get permission to apply, because you've already been order removed, and because your case hasn't been dismissed yet. That's why you have to go outside. But in order for you to go outside, they have to apply for it. So if you get granted, good. If it doesn't get granted, you can't go outside because you'll be blocked there. So yeah. And if you look at the instruction on that form, it's going to tell you who is eligible to file and who's not eligible to file. Like, you are eligible to file, but it doesn't mean it's going to be granted. It's just up to USCIS to decide. You're eligible because there's no way for you to adjust status here because your case is still with the court. Okay. Yeah, McIntyre, you need to let me send you the link for consultation, because I feel like you need a consultation so somebody can take their time to explain to you what's going on with your case, because it looks like nobody's explaining to you. McIntyre, this is the link for consultation. Okay. Okay, so what is SA saying? SA is saying the Sixth Circuit remanded my case to the BIA. After a joint motion with OPLA based on, okay, the Chavez Garland, I'm waiting for a decision from BIA to apply for cancellation. Okay. Yeah. So the only thing you can do is wait, because your case is already at the BIA. So the BIA has to decide based on Ms. Chavez v. Garland. Remember that it's because you got a notice to appear which was defective. Okay, that's why you had the right to go back and to the Sixth Circuit, so they can remand your case back to BIA to make a decision on it. So now the only thing you do is wait for BIA to make a decision, which they're really gonna. It's like it's a good decision for you because the Sixth Circuit has already remanded the case back to them. So it's gonna be a good decision, and you're gonna be able to apply for cancellation. So it's now up to the cancellation of removal to be granted based on the qualification of cancellation. That's it. So the only thing you do is wait. There's nothing else you can do at this point. It's just wait. BIA, they take their time, but they will decide eventually. Ask Tower. He's gonna tell you how long it takes for BIA to decide. Almost 2 years. Okay. Struggling how? Define struggling for you. Yeah, define struggling. They're struggling how? Like they're not getting good grades? Because remember, cancellation of removal, I've talked about it before. It's very high standard. They have to, the hardship has to be extreme and unusual. meaning that it has to be something that it doesn't happen to everybody. The type of hardship that you're experiencing, it's not common to everybody. For example, let me give you examples. For example, if you have a child who's sick, like they have to go through surgery, or maybe they have sickle cell diseases, those type of things that's so rare because not every child goes to surgery, right? So that can qualify as a hardship, extreme and unusual. So special education, IP, people use it, but they have to use it, they have to use it combined with a lot of things. Because if they don't use it combined with a lot of things, well, it's not really extreme because, you know, in America, almost 50% of children, they are in IEP. IEP. Almost 50% of children. So they have to combine with something else. Yeah, it's just going to depend on how your lawyer is going to argue for you. But if you ask me, is that extreme and unusual? I will say it might be extreme, but it's not unusual. Okay, but it just depends how they're going to present your case with all other additional circumstances. Um, and if you're lucky, you gotta be lucky too, right? If you're lucky, then it's gonna work too. So what I will say is just wait and see how it's gonna go, because nobody can predict and tell you for sure it's gonna be granted, you know. But just depending on how they are presenting your case, yeah. Yeah. You are going to hire me after you already hired somebody else? Huh, interesting. Interesting. By the way, so just wait, you know, um, just wait and see how it's gonna play out. Especially now that you're already at BIA, really, there's nothing you can do. You just wait. Eventually, they get to your case. They will get to your case. They usually take 1 year, 2 years, 3 years, but eventually they will get to your case. Uh, Seaman visa. Crew member, can their children wife file for them without leaving the USCIS? You're welcome, sir. By the way, please like and share. You need to like and share my videos with your friends. Since you didn't hire me, maybe your friends can hire me, okay? You need to like and share. Please do that. Okay. Well, JamericanTV.com. Someone who came with a crew member visa. Can their wife file for them without leaving the USA? The short answer is crew members are not allowed to adjust status. That's just the short answer. I'll say no. However, in some circumstances, spouses of US citizens can file for a waiver, hardship waiver, and hope it gets granted. But in most cases, really, you have to do consular processing. You're going to have to get a I-601A waiver and then go through consular processing because of that type of visa, crew member visa. Yeah, so that's what I just answered you. Were you listening? JamericanTV.com. I just answered that question. The short answer is no, because it's a crew member visa. Seaman, it's crew member visa. The general rule is they cannot adjust status inside of the US. They have to go through consular processing. Okay. But some people, they try to get a waiver if they marry a US citizen. They file for a waiver of hardship, and hope it gets granted. If you get granted, then yes, they can adjust status under marriage to a U.S. citizen. But if not, then they just have to go through a consular processing. So the short answer is no. That's what I'll say as an answer. But then you go to this exception and hope. You're just really hoping. Okay. JamericanTV.com. Please like, please share. Please like, please share. Let me put a consultation link here. If somebody need a consultation, they can schedule it here. Yeah, I was talking about news, right? I have another news to share. I got sidetracked. Okay, so the news I was going to share with you is about a class action lawsuit for Imani v. Nielsen. So what's going on is that if you're Muslim and you are part of the Muslim ban, you couldn't get your visa, immigrant visa, to get to the United States, then you can join this. Let me share my screen so I can explain it correctly. Okay, let me share my screen. Okay, so let me share the screen. Okay. So they are calling out plaintiff, okay? Plaintiff for class action lawsuit. So this is a case where a Muslim under the Muslim ban was prohibited from getting a visa based on this Muslim ban. So now people are filing a lawsuit to lift that ban, okay? So if you are Muslim and you're part of that ban, you have to join this lawsuit no later than they're asking for people to join no later than January 31st, 2024. So let me explain who's qualified to join, okay? If your applicant was denied visa under ENA 212F between January 2017 and January 1st, 2017 and January 2021, the applicant visa has still not been issued. Applicant cannot be a DV lottery winner. If you qualify under those two, you can join that lawsuit, but you have to be a Muslim under the Muslim ban, okay? That's for immigrant visa. If we're talking about non-immigrant visa, then the applicant was denied visa the same date. Applicant has not subsequently received a visa, or if applicant has applied but is still in administrative processing, okay? There's no cost to join this class action lawsuit. There's no harm in joining the suit either. If anything, we see that our name plaintiff tend to be lucky to get their visa issued. If you have a client that meets the criteria and is interested in joining the suit, please email. Yeah, if you join, you can email me. I can send you the email. If you're Muslim, I'll send you the email to those people so you can join the lawsuit, okay? So what else? I have another news I wanted to share. Okay, let's see. I have another news I wanted to share. This is, it's very important news as well. Yeah, so DHS notice of extension and redesignation of Syria for TPS, okay? They're gonna redesignate TPS for 18 months for Syria, beginning April 1st, 2024, and ending in September 30th, 2025, 18 months for Syria, okay? The notice will be published on the Federal Register on Monday, okay, tomorrow. That's good news for Syria. What else? This is the last news I want to share, because I talk about this one, the DOS States Visa Renewal Pilot. That's for H1B visa. I talk about it. Yeah, this one is the last one I want to share. This is very crucial, okay? The Supreme Court to hear a case involving consular non-reviewability. Remember, if you follow me on Instagram, that's why I keep telling you, you need to follow me on Instagram, okay? Because sometimes I explain with my slides, I explain a lot of things that can be beneficial for you or family members that are willing to petition. Sometimes you need free resources like that. That's why you need to follow me on Instagram. So important. Even TikTok, sometimes I answer those questions. Facebook page, I post all my live sessions there as well. I mean, at least not all of them, but I have to start posting most of them over there. But anyway, what's going on is this, right? We know that at the embassy, when they deny you a visa, what's going to happen is you have no right to review it. Then they came up with a case where this person asked the federal court to intervene and then explain to them that they have to give them the reason why they denied the visa and give them the opportunity to respond. So that's why certain cases, they start giving reasons, but still, because the law is not final yet, because now the Supreme Court is going to hear this case one more time so they can come up with a rule that's going to settle this problem once and for all, so that people can have some type of reason given to them as to why their visa were denied at the consulate. Because the consulate, once they deny the visa, they don't give you any reason. That's why people have been suing in federal court. Okay, those are the issues, right? Whether a consular officer refuses of a visa to a U.S. citizen, non-citizen spouse, impinge upon constitutionality protected interests of the citizen, and whether, assuming that such constitutional interests exist, notifying a visa applicant that they were deemed inadmissible suffice to provide any process that is due. Okay, they have to explain to them why they are denying the visa with ample, like with details, not just say you deny visa under 212A3AII. That it has to be very clear. You did this, you did, like the facts. You know how they didn't, when they deny you a visa, a petition here with USCIS, they'll send a letter and explaining the facts and everything and the reason why it's been denied. So they're trying to get the consulate to do the same thing. Okay, stop sharing. That's about it for immigration news. I talked a lot today. That's about it for immigration news. If you're in Texas and in Florida, my friends, stay out of trouble because it's going down over there. It's so bad. You don't want to be caught into those things, okay? Just stay out of trouble. You will be out of removal proceedings, okay? So I'm trying to go back. For some reason today, I'm having trouble with this computer. Okay. Okay. Thank you. I appreciate it. You're welcome. My work permit due to adjustment of status will expire on October 24th. It's also with VAWA. Do I have to pay for the renewal or no fee? Renewal, you're going to have to pay because it's a renewal. Yeah. Renewal of work permit, you really have to pay. That's what I know for sure. But you can Google it too on calculator. But I know renewal, you have to pay. It's the first time when you apply with everything that you don't pay. Anybody else, please like, please share. Don't forget to like, don't forget to share. Until next time, bye-bye. I'm gonna try to respond to some questions again on TikTok. Until next time, bye-bye.